Thanks for staying with us. Former Public Protector CEO Vussy Mahlangu testified before the Section 194 committee today. He's denied claims that there was a butchering and intimidation of the employees during his tenure. At the same time, there was also drama in another legal matter, which was the Senzo Meyiwa murder trial. Advocate Malesela Teffo was expected to be back, but wasn't, which led to much confusion. Let's speak to legal commentator Sinawo Makangela, who joins us now to also look at these stories, as well as the Krugersdorp case following the rape of 8 women last week. Thank you so much, Sinawo, for your time. Listening to, the proceedings in Parliament today, some employees, if you were listening to them even over the course of the past few days, they're painting a picture of what appears to be a reign of terror, where they say that there was a purging of those who spoke against the public protector. But we're listening to the CEO, and he denies that any of this was taking place, saying all the disciplinary processes were legitimate. I wonder, when you listen to the evidence today and juxtaposing it with what we've heard, do we have an understanding of what may have been happening in that office?
Thank you, Sisbongi, and good afternoon to the viewers as well. Well, the CEO now has given a totally different testimony as compared to all other witnesses that have come before the committee. It's a different version altogether. He's not concurring with them. But centrally, what he says, I noticed that in summary, he's agreeing with the counsel for the PP, in that all those who are disgruntled, anyone who's adversely affected by the process, the disciplinary processes, would go out and say whatever they want to say. So actually, he's denying the fact that he was butchering the employees. He says all those disciplinary processes were legitimate, was dealing with the employees. He took it further to say some of them were disciplined because they could not take the investigations anywhere. So they were delaying the investigations. They were sitting over those investigations. Some were settling dusts in the PP's offices. So that is his testimony for today. But of course, there are those employees, some of them, we saw some tweets that were shared then to say you must leave, take responsibility, you must start owning up to whatever that is happening in the office, because you must understand the stature of that particular office. All that is coming from those employees. Remember, well, unfortunately, as we all know, that this is a parliamentary committee. If it was a court of law, that testimony would have been approached with a serious caution. Remember, a disgruntled person would say anything to salvage his own situation. Remember, if you recall one, Mr. Kekana, if it was him, who said, I had to prepare this affidavit to this committee to save myself from further charges. If you take that line as well, it says whatever testimony they bring to Parliament, the parliamentary committee will have to apply its mind objectively on the matter.
Now, when we are looking at these tweets, I mean, we saw even, for example, the former senior investigator Mpusang Isaac Matlawe, who was posting those series of tweets saying that she was lazy. That is why there was, questionable, outcomes when it comes to her reports. Also painting a picture of the fact that she's fake. Among some of the tweets that he posted, which were also picked apart. Let's talk about, these tweets. How much of a bearing will they have on this matter that is being decided upon right now?
Actually, they will be helping the committee, but they must not only be alone, only to support a certain testimony that must come before committee. There's a question here that says, was actually by the former CEO to say, there was never a moment where they analyzed that actually this is the line of the judgments, this is the line of the cases. This outcome to say the PP's office has been losing cases, it is because of the laziness or failure to apply their mind. Once there is that testimony, it's supported by those tweets, then there's more case now against the PP. But as he speaks now, he says they never sat down to analyze. But what he says is that the reason why litigation has risen in that office, it's because of the Nkandla judgment. Because the Nkandla judgment said, you can't just sit idly if there are findings against you by the PP. You must go to court. So literally now for every finding, one must run to court to review them. If you look at the history before the Nkandla judgment, some decisions, some recommendations by the PP have been shelved. Nobody knows what happened with them. But it is post the Nkandla judgment that the litigation has skyrocketed against the PP's recommendations.
So very quickly, pardon me for coming in there. Very quickly then, let's look before we move on to other matters, because there are also some serious allegations that were also put to the fore against this particular witness, and talking about how this, there were allegations that led him, for example, to be fired in the Department of Rural Development. At the same time, we also heard issues around his security clearance. Does this affect his credibility at all as far as this process is concerned?
Well, if the scope of this committee goes to that extent, obviously it does. It will tell that in the first place, he ought not to have been there. So he was in the wrong place at the wrong time. He should not have been appointed to occupy that office. If it requires him to possess that security clearance, whoever had a duty to do that, it means somebody derelited that obligation, and which is wrong. Now, the parliament will be found wanting now to deal with this kind of a testimony at this stage, because their issue is to check whether there's case of gross misconduct against the PP. So other people will be what you call collateral. They will be affected, as now this is coming up, that actually even you, the CEO, you are not supposed to be there.
It's going to be interesting to see how this process unfolds, especially when we look at that issue from yesterday where the Vrede Dairy Farm investigation, unfolded with that picture. But let's move on to what we also saw in court today. Very confusing developments from the Senzo Meyiwa case. I mean, Advocate Teffo had said that he was coming back, and we then heard from the instructing attorney in the case saying that as far as things stand, he's the man that is going to now continue with this particular matter. I wonder, given what has happened in the public domain, what do you make of this?
Ms. Bongi, I can tell you now that what we see unfolding in that court is not how things should be done. There's what is called a decorum. The language used in court, how you address a judge, whether you may have your own reservations, because there's always an alternative. The judge presides over the matter, gives direction. You don't argue, you persuade, you make submissions, you represent your client without fear or favor. But you do not do that by disrespecting the court. The court processes are regulated by the rules depending on the nature of the proceedings. The criminal proceedings are regulated by the Criminal Procedure Act. Whatever application, whatever process that you have to make there, you have to follow the act. We all know, as the judge has indicated from the beginning of the proceedings, that today the court was sitting to deal with the issue of jurisdiction, because for accused 1 and 4, they questioned why the matter was heard in Pretoria than Johannesburg. So the judge requested the parties to submit heads of arguments to make the proceedings to flow, so that it can be easy for the judge as well to quickly make up a decision. We know how serious this matter is to the Meyiwa family. What happened in between? Counsel for accused 1 and 2, Mr. Teffo, came saying he was withdrawing. We now know before today, some letters were circulating, accused everyone, the judges. Those things are not done in our system. It's just undermining the system. It's not to undermine even Judge Mahomelo, but just to undermine the system. There are channels that every legal practitioner must follow. If you've got a complaint, if you have an issue against the judge, there's JSC. We know there's a process. If you've got an issue with the prosecutor who's prosecuting the matter, you follow the law as well there. You don't just throw wild allegations.
Now, talking about these wide allegations, let's talk about, I mean, he talks about sangomas and all of that, but how do you see this letter being dealt with? Because, his instructing attorney says this letter was written post him being part of these proceedings, but at the same time, these allegations have been made, they're in the public domain. How do you see it being dealt with going forward?
Sisbongo, even these letters are just a distraction. If you look at them, they're just distracting these proceedings from. Look, there's a Meyiwa family that wants justice. A decision has to be made in finalizing this matter. A letter is written, this allegation and that. Remember, as legal practitioners, we have an obligation not to personalize the cases. That is why you owe it to the court to ensure that whatever document that is going to make its way to the judge, you must share it with the colleagues. You don't catch anyone by surprise when you get to court. Simple things, basic things, the colleagues there in court don't even know what is happening in the letter. They want to put those letters on records. That's not how the court processes should unfold.
And
share the letter, share it with the prosecutor, and then you put it on record. You follow the process. Even there, whatever document. As I say, as South Africans, we've been following all proceedings in many courts. This is not the first case. We know that there will always be some kind of evidence, some kind of a process that gets to be followed. You can't have any court without the processes that are being followed. And the person who guides those proceedings is always a judge. You can't argue with the judge when the judge is guiding that process. Whether the judge is right or wrong, you will always have a recourse. If you feel strongly that the judge is missing the point, at least you go to the next platform. You appeal to the full bench. There are 3 judges. You are not happy, you go to the SA. You are not happy, you go to the court. You don't just derail the proceedings.
I get the feeling, Sinawo, that you and I are going to talk about more installments when it comes to this one. I don't think we've seen the last of him as far as this case is concerned. But let's move on to, as we wrap up the issue, around the rape of 8 women, that horrific story in Krugersdorp, over 80 people being arrested. But let's talk about the process now, because we do know that at the moment there have not been any, linkages, if I may put it that way, to, and the charges brought as far as this rape is concerned. It's just been around the violation of the Immigration Act, etc. Let's talk about the process now that is going to unfold, particularly looking at the legal one of linking some of the suspects here to the actual crime.
Well, Sisbongo, usually as a process, if the victims do not know probably those who have committed the offense, there would have been the identification parades. Post that, there would be the DNAs conducted and all such process that must go to the labs, and then they receive the outcomes. They see, and then the investigating team will see if they need to add charges on top of the breaking of the immigration laws to these accused persons. They're just the first. These are the first charges that they believe that they've got a case on. Does not stop the prosecution from adding all other charges as the time goes by, if they are able to gather enough evidence, by the way, to do that.
All right. Now, thank you so much for your time. Do appreciate it this afternoon. That was legal commentator Sinawo Makangela.